Hello again, everyone. I'm attorney Robert Flessis, and thanks for choosing to watch this video. What's a secured debt and how is it treated in a Chapter 7 bankruptcy? Well, secured debt does two things when it's created. First, it creates personal liability, obligating you to repay the debt to the creditor. Second, it creates a lien on property that's used as the collateral for the credit. The creditor then has what's called a security interest. Security interest can be created either voluntarily or involuntarily. Involuntary liens are imposed upon you without your consent. Here are some examples. Tax liens are usually IRS or government taxing authority liens. You didn't agree to that lien. They just slapped it on you, and it goes against any real estate that you may own too. You can't eliminate IRS liens in bankruptcy. However, there's a formula that could qualify you for discharge of that debt, but that's left for another video. Judicial liens are non-voluntary liens that are granted by a court in the form of a judgment. Usually, judgments are obtained by credit card companies, debt buyers, and landlords as money judgments when you fail to pay them. Statutory liens are non-voluntary too. The most common statutory lien is created when you hire a contractor, let's say, to work on your house and you don't pay them. They put what's called a mechanic's lien on your property that's automatically allowed by state statute. Now, voluntary lien examples are as follows. A home mortgage or car loans are voluntary. You agreed to the lien. You gave your consent to the lien. When it comes to real estate, you can't eliminate the lien. If you're behind on mortgage payments, then the lender may be willing to adjust your payments by modifying your loan. But if you owe many payments to the lender, then you may not be able to keep the home. The lender may file a motion asking the court to lift or remove the automatic stay that protects you. The automatic stay stops creditor action. If the court lifts the stay, then the mortgage lender can proceed in state court to foreclose on the property. But that topic is for another video. If you're currently in a foreclosure action on your home and you're never going to be able to catch up with the delinquent balance, then it's sometimes better to surrender the home to the lender. That eliminates any personal liability for the mortgage. Auto loans are voluntary liens. They're called purchase money security liens. They're created when you purchase a car and need credit in order to purchase the car. Otherwise, you couldn't afford to buy it. The car now becomes the collateral for the loan. If you stop making your car payments, then the creditor can repossess the car. In bankruptcy, you have only three options when it comes to dealing with vehicle debt. One, you can pay the creditor the replacement value instead of the loan balance, but most people can't afford to pay the amount of the replacement value. Second, you could surrender the vehicle to the creditor. Third, you can sign what's called a reaffirmation agreement that would continue your personal liability for the loan. But reaffirming on a depreciating asset is not a good idea. In most cases, if you need to keep the vehicle, you have the right to not sign the reaffirmation agreement, but you must continue making the monthly payments and maintain proper insurance on the vehicle. As long as you comply with the terms of the auto loan, you're in good shape. But if the car is in bad shape or you owe a lot more than the value of the car, then it's probably better to surrender it. Surrendering will eliminate your personal liability for the balance of the loan, and you're done with it. In a bankruptcy petition, for any secured property, you must indicate your intention of whether you're going to surrender the property, keep the property, or redeem the property. That's called the statement of intent, and it's giving the lender notice of what you intend to do with their collateral. The statement of intent is usually filed along with the papers that you filed that commence the bankruptcy case. If not, the statement of intent must be filed within 45 days of the date of the case filing or 30 days from your creditor meeting. I'm attorney Robert Flessis, and thanks for watching.